Hi, this is Professor Higgins, and welcome to week 6 of our business organization class here at Valencia College. This week, we're going to be focusing on limited partnerships. Now, we've gone over in our previous lectures sole proprietorships, and before that, we talked about the law of agency, which is applicable to every business entity that we will go over this semester. Then we looked at general partnerships, and then the week following that, we looked at limited liability partnerships. So this week, we are looking at a business entity which is called a limited partnership. And so let me start off here with the definition of a limited partnership for you. A limited partnership is a partnership that is created by Florida statute with one or more general partner and one or more limited partner. So you will have one general partner, which we already have talked about. What the general partner in a limited partnership is the same as a general partner in a general partnership. So we have one of those. We have at least one of those. There may be more. There's no limit, but you have to have at least one general partner. Then you also have to have one limited partner. Now, historically, these entities were very popular. There were like 22,000 at one time, limited partnerships in the state of Florida. Today, in 2021, we have maybe 1,000 of them that are still operating. So they're not very popular anymore. And we're going to discover why they've lost their popularity. Now, a limited partner is a partner who makes a contribution of cash or other property to the partnership and obtains an interest in the limited partnership in return, but whose liability for the partnership is not unlimited personal exposure like a general partnership is. Its liability, the limited partner's liability in the limited partnership, is limited, thus we call it a limited partnership. It is limited to whatever the amount was that the limited partner contributed or contributes to the partnership. So however much money they contribute to get the thing started, that's all they can lose, except if they continue to make contributions. So they are limited to the amount of the contributions that they make to the partnership, to the limited partnership, and that's all they can lose. Now, a general partner, well, let's go take a look at the formal definition that I have here for you. A general partner is a partner who assumes the management responsibilities of the partnership and has full personal liability for the debts of the partnership if the limited partnership doesn't have the money to satisfy those debts. Okay, now, a general partner and a limited partner may be a person, a partnership, a limited partnership, a trust. It can be a limited liability company. It can even be a corporation. So per Florida statutory law, a general partner can even be a limited partner. But I just want you to get the idea that Florida statute has said that the partners don't have to be human, blood bleeding persons, that they can be an artificial person as well. Okay, why would somebody want to form a limited partnership? Well, historically, there were tax advantages to being a limited partnership, but really not so much anymore. What was happening long ago with the general partnerships was that you would have partners who would get together and they would have these great ideas and they would want to start these businesses. And sometimes there would just be one person who had a great idea, wanted to start a business, but they didn't have money to start the business. So they would go tell their friend who had a lot of money, and they would go into business with them. They would start a general partnership, and that general partnership, if it got into trouble, if it got sued somewhere down the line, what happened was when the plaintiff was suing the general partnership, well, they know there's joint and several liability, and the innocent third party, the person who was suing, would just sue the partner with the most money. So what happened was there were a lot of people who wanted to invest in business, and they wanted to invest with their friends because they thought they were really smart in some area, but they couldn't because the exposure was so great. The personal liability exposure was so great. So what the legislature did was they devised this thing called a limited partnership, where you could have a very, very wealthy partner, and they would just come in and drop in $100,000, but that's all they would lose if the thing went south. If they went out of business, went bankrupt, or if they got sued for everything, they would be protected, and the only money they could lose was the money that they had put in. Now, the general partner, on the other hand, who is still sticking around with the unlimited personal liability, you can go after them as a plaintiff. The innocent third party can still go after them personally. But this type of business entity protected wealthy partners who wanted to give the general partner, who maybe had the knowledge or the education or the expertise or whatever it was, to go out and make a business, but he couldn't or she couldn't because she didn't have the means. And so this was a way of that person getting the means while protecting the other party who was providing the means. All right. What law governs? Well, I've said the Florida statute governs the limited partnerships here in Florida, but they came from, and they were adopted by Florida in 2005 from the commission that, actually it's the same commission that did RUPA, and they created what is called the Revised Uniform Limited Partnership Act. RULPA. It has the L in there. It was codified, and I've given you the code. It's 620.1101 to .2205 in our Florida statutes. It's in your notes that I've given you. And this law applies to all of the limited partnerships that were created since 2007. This 2005 Act is somewhat different than the 2001 Act that is discussed in your text. But this is the one that I want you to know and be familiar with for the state of Florida. Okay, let's talk about forming a limited partnership. Everything that you learned that we started with the sole proprietor to figure out what you're going to do to start a business, all of that applies. You do all of that. Plus, the limited partnership must, and I want you to underline must in your notes, must file a certificate of limited partnership, because we are giving notice that this business entity is a limited partnership. And so if I am starting a business and I'm the general partner and I'm starting a partnership, a limited partnership, and my limited partner is Shaquille O'Neal, then it puts everyone on notice that if they want to sue our business, they can come after the business, and then they can come after, of course, each of the partners. But Shaq is going to be protected. He is only going to be able to lose the amount of money that he put in. Me, I am the general partner, so I am still personally liable. Once the limited partnership is sued and it runs out of money, and you run out of the $100,000 that Shaq put in, then the rest of it you have to come after me for. All right. the limited partnership must file a certificate of limited partnership. It has to be signed by each general partner. It's filed with the Department of State. I don't know if I said that or not, but the Secretary of State, who is the head of the Department of State, that is who you will file with. And it should contain the following information: the name of the limited partnership. And here in the state of Florida, we have to have the words limited partnership, or LP, capital L, capital P, at the end of the name, or L period P period. That way, everyone knows that it's a limited partnership and there's a limited partner that's being protected. Now, the name of the partnership cannot have the name of that limited partner in it. That's according to law. All right, obviously we'd have the address of the office and the address of wherever the registered agent accepts service for us. The third thing is the name and the address of each general partner. Again, the limited partner's name and address is not required because you're usually trying to protect that individual. You want to protect him from or her from being sued, and so there's no address for that person provided. And then you want to state whether it is a limited partnership or a limited liability limited partnership. Now, today we're just going to talk about the limited partnership. So that is something that has to be on that certificate of, make sure I get this correct, of limited partnership. Okay, what is the purpose of filing the statement of limited partnership? Basically, so the innocent third party, if they suffer damages at the hands of the limited partnership, they will know who to sue. And that is going to be the general partners. Well, they're going to sue the partnership, the limited partnership, and then they will also sue the general partners individually. It gives all potential creditors notice of the limited liability of the limited partners. And as to creditors, what is on file governs. So even if the partnership agreement says otherwise, it's going to be whatever is on file for that creditor is going to govern. Meaning, if one of the general partners later becomes a limited partner, if they have not filed and changed, you have to amend that statement or certificate of limited partnership. If you haven't amended that, then you're still considered a general partner, and that still applies. That you still are able to be sued. Okay. How expensive is it to file this form? Well, this is one of the state of Florida's most expensive forms. It is $965 to file, and then you also have to have an acceptance by the registered agent, which is another $35. So bam, right off the bat, you're looking at $1,000. Now that's much more expensive than a sole proprietor who doesn't have to file anything, and a limited liability partnership or a general partnership. The forms that they file are generally between $25 and $50. So this is something that you go, the state of Florida is making people who want this type of business entity pay more than 10 times what another business entity is paying. So let's just tuck that away and keep thinking about it. Once it's filed, what happens? Once you file that certificate of limited partnership, you now have a limited partnership. That's when it's born. But there's still other requirements that you have to do. The limited partnership must, and I say must because I haven't said must very often. In fact, I haven't said it at all. You don't have to have a partnership agreement in a general partnership, because if you don't have one, then RUPA applies. However, in a limited partnership, you must have a partnership agreement. And if you have a lot of times we'll have clients that you ask them if they have, let me see your partnership agreement. They don't have it called a partnership agreement, but they have a writing that is kind of governing them, and that's what you're going to use as their partnership agreement. The partnership agreement has to have these things. Number one, the amount of cash and or services and the agreed value of property contributed by every partner. So maybe one partner is only bringing expertise. That has to be laid out in the valuation. Maybe one of the partners is contributing $100,000. That has to be laid out and valued at $100,000. Maybe someone is providing a tow truck, and so that is going to have to be valued. All of that has to be in the partnership agreement of the limited partnership. You also have to have the times of or the events upon which future contributions are going to be made. So you have to have in your partnership agreement when everybody's going to make another contribution. Maybe after that first contribution, every month, the limited partner is going to put in another $25,000, and the other partners who are providing services or the truck, maybe the fellow who's throwing in the pickup truck or I think we said tow truck, he's got to put in, they're putting in another $1,000. So it doesn't matter what it is, but you have to have it in writing what the future contributions are going to be. Now they can be every month, they can be every year, they could be every 10 years, or they can be when certain events happen. It can be as silly as whenever you have a child or every time you have pizza. But generally it's more on the lines of when this road gets finished. Maybe if we're paving roads with our tow truck. Maybe it's when each road gets finished or each project gets completed, everyone has to put in some additional something. It doesn't have to be cash. It can be services or in-kind contributions, anything that you decide on, but it has to be in your partnership agreement. And then you also have to have the events of dissolution. What is going to cause dissolution? You have to be able to say that you're going to either be a limited partnership in perpetuity. You have to say if you're going to be a limited partnership for a month. You have to say if you're going to be a limited partnership until the end of the 2024 World Cup. I don't even know if they're having a World Cup in 2024, but there has to be some kind of deadline and what event is going to cause the dissolution. Okay. Third, every limited partnership must maintain in the state of Florida an office which has records of its certificate of limited partnership, its partnership agreement, the names and addresses of all the, yes, you got it, general partnerships and limited partnerships. Now remember, this is kept in the office. This is not written down and filed with the state of Florida. But in your office, you do have a list of all your general and limited partners. And its financial statements and income tax returns for the past 3 years. Okay? The fourth and final thing is the limited partnership must file an annual report once a year. They have to do that with the Secretary of State, and they have to do it between January 1st and May 1st. They do this every year, and they pay an annual, I think the annual fee is $411.25. Now, if you don't file the annual report, then you could be, your limited partnership could be administratively dissolved. The Secretary of State could say, hey, they didn't file their annual report, they didn't pay their $411, so they are no longer a limited partnership. But we'll get to that in a little bit. All right, the financial structure of the limited partnership. You have the initial contribution from each partner. It can be cash, it can be property, or it can be services. The second thing that you do after in the financial structure, after the initial contribution, the second financial thing you need to talk about is the share of profits or losses. Now remember, in the general partnership, everything was even Steven. If your partnership agreement did not say or indicate how you were going to split up profits, how you were going to split up losses, what contributions were made, everything was just assumed that it would be all split up equally. If you need more money, got to split it up equally. If you're fussing and fighting over how the profits are going to be split up, everything was equally. Now, because we have this limited partner who is probably putting in a lot more money than the general partners, or however, a bunch of limited partners, if maybe you have one general partner and a lot of limited partners, but it doesn't matter. The share of losses and profits are going to be allocated according to the partnership agreement. Remember, it's required to be filed. And if the agreement is silent, if you went ahead and you filed your partnership agreement, but you didn't talk about the allocation of profits or how you were going to split up losses, then the profits and losses are going to be allocated not like the general partnership, but they're going to be allocated based upon the value of the contributions made by each partner. So if one partner contributes 90% and two other partners contribute 5% each, then if they make $1,000 at the end of the first month and they have $1,000 profit and they're getting ready to distribute it, then the person or the partner that put in the $90,000 is going to get $900 back in profit, and the other two are going to get $50 back because they're only getting their 5% recognition that they put in as their contribution. Now, as far as the management of a limited partnership, both general partners and limited partners may, and I'm just saying may, they both may participate in the management and the control of the limited partnership. The limited partner, remember, is only liable to persons who transact business with the limited partnership who reasonably believe that based upon the limited partner's conduct or behavior, that the limited partner is really a general partner. So if you are a limited partner and you are pretending like you're the general partner, then you are going to lose your limited partner status as to that one particular client. But it has to be proven because both general partners and limited partners do have the opportunity, if they want, they can both make decisions and manage and control the business, but the limited partner still has to make sure that everyone understands that they're a limited partner. If they mislead, or if the person just based on the behavior of the limited partner thinks that they're a general partner, then that's all it takes, and they lose their limited partner status, which means they no longer, their liability is not limited for that particular customer. All right, so what are the rights of each of the partners? Well, I'll tell you. The general partners can manage any matter related to activities of the limited partnership and the majority rules, unless, of course, the partnership agreement says otherwise. But for certain matters, all general partners and all limited partners must unanimously agree. And here are the things that all of the general partners and all of the limited partners have to unanimously agree upon. All right. Number one, if they are going to amend the partnership agreement or the certificate of limited partnership in any way, everybody has to agree. All the general partners have to be on board, as well as all the limited partners. if they are going to admit a new general partner or a new limited partner. All the general partners have to agree, as well as all the limited partners. And compromising a partner's obligation to make a contribution. So let's say every year, all of the partners, all the general partners and all the limited partners are going to throw in $10,000 a year every January 1st. Well, one of the partners has had a difficult time. They lived here in Florida, and there was a hurricane, and they suffered greatly, and they just can't get their head above water. If all of the partners, all of the general partners and all of the limited partners agree that they can excuse that partner's obligation to make a contribution, then that's fine, then they do. However, if one says, nope, that's not okay, they have to come up with their $10,000, then they have to come up with their $10,000. So those are the things that take everybody agreeing on them. Now, when it gets to dissolution, only the general partners have to unanimously agree on the following. Expelling a limited partner. If one of the limited partners is going to get kicked out, all the general partners have to agree. If they are going to approve a plan of converting from a limited partnership to a limited liability company or to a general partnership or anything, if they're going to convert their business entity to become another business entity, then only the general partners have to unanimously agree. And the last one is disposing of partnership property. If any property, maybe they're going to sell a truck or maybe they're going to sell some real estate, all of the general partners have to unanimously agree, and the limited partners do not have to be involved. Okay. Partners' rights and responsibilities. Well, there's going to be different rights and responsibilities for each class of partner. The general partners are going to have rights and responsibilities, and the limited partners are going to have different rights and responsibilities. So basically, the general partners, let's talk about the general partners first. Basically, the general partners do the same thing as general partners in a general partnership. Let me get my notes straightened out here. All right. For a general partnership, number one, the general partners have the right to share in the profits and losses based upon their percentage in the contribution. Remember, it's not even Steven anymore. It's in proportion to the amount you have contributed to the company. They have the right to assign their partnership interest to another. They have a right to transact business with the limited partnership. They have a right to withdraw from the partnership. They have a right to dissolve if it is not reasonably practicable to carry on. And they have a right to manage. They have equal rights. All the general partners have equal rights to management. And then as far as responsibility is concerned, general partners have a fiduciary duty to the limited partners. Fiduciary duty means that they have to be the utmost honorable, trustworthy, and honest when it comes to any money or financial matters. They are agents of the limited partnership, and they bind the limited partnership if they are acting in the course and scope of their business. All right. The limited partners. Unlike the general partner, a limited partner has no fiduciary duty to the limited partnership, and they can act within their own best interest. Let's say I'm a wealthy woman, and I love donuts. And so in the area of Orlando, I decide, you know what? This little town doesn't have enough donut shops. And so I begin investing in donut shops. I don't know who makes the best donuts, and I don't know who advertises the best donuts, and I don't know who has the cutest place or is located in an area where there's a lot of hungry donut eaters coming, or students that are heading into school, because I know students like to bring donuts to class. So what do I do? I invest in every donut shop in Orlando that I come across. So if you're a donut shop, I want to invest because I know donut shops are going to make money. And I figure the more money that I put into donuts all over the city of Orlando, the more money I'm going to make, because there are some donut eating people in this town. So I do maybe a general partner. If they were running a donut shop, they would never go out and give money or services or advice or expertise to their competition in the marketplace. But because I'm a limited partner and I'm just really investing to make money, and I think all donut shops are going to make money, and I can invest in, they can all be competitors of each other. And so they're out there working and trying to sell the most donuts. Really, that's just working out better for me. So I have no fiduciary duty as a limited partner to the limited partnership itself. I'm just here to give them my money and to hope they can make me more money with that. If, however, the limited partner, that's me in this case, if I choose to jump in and start participating in management, then I become an agent of the limited partnership, and I would then owe my partnership a duty of loyalty and care. That means that I cannot go dropping money into all these donut shops. If I'm going to start running one and telling them how to run their business and how to manage this particular donut shop, then I have to divest in all of these other donut shops. If I want control, then I have to be loyal, because otherwise someone could get into I could say, well, I'm going to be a general partner and I'm going to start making decisions as a limited partner in this donut shop, and I could run it into the ground so that my other donut shop will make a lot of money. So once you begin giving advice or being involved in management at all, then you have a fiduciary duty and you can no longer be invested in the competition. Okay, both general partners and limited partners have the right to inspect all the books and all the records, financial and otherwise, of the partnership. These are required to be maintained by law, to be maintained. And any general partner, any limited partner can go take a look at them and see where the company stands. Now, as a limited partner, I might just be somebody who's trying to make money, and that's all I'm doing. And so I have money that I've invested into this donut shop, and I might just be curious. I wonder how well they're doing. So then I go and I take a look at their books, and also my attorney can do that as well. All right, dissociation. Let's talk about the withdrawal of a partner. General partners and limited partners in section 620.1601 all the way to .1604 in our Florida statutes state that a general partner or a limited partner may withdraw from a limited partnership at any time by giving notice to the other partners. If the withdrawal violates the limited partnership agreement, the other partners may sue the departing partner for damages caused by breach of the agreement. Okay, I think you remember some of that from our general partnership assignment. So, if I'm supposed to work for a year and I work past that and then I decide, I'm going to give my notice and I'd like to dissociate, no problem. But if I have committed to stay for 5 years and at the end of the second year I decide to dissociate, then if there's any damages that are incurred by my departure, if I cause any loss of business because I'm no longer there, then I will have to reimburse or pay the damages that were suffered by the other partners. If the withdrawal violates the limited partnership agreement, the other partners may sue the departing partner for damages caused by the breach of the agreement. Okay. Usually people can work that out. They can usually, if one of the partners wants to dissociate, they can usually talk about it. and they end up buying him out. And maybe if they feel like, well, we're going to lose some business because people really like you around here a lot and you bring in a lot of our business, then maybe they just don't buy him out as high. They don't give him as much money. But he's not expecting his money. When you dissociate, you don't automatically get a cash payout right then and there. It depends on a lot of things. You have to wait, until the partnership has that money, or sometimes you have to wait until the whole thing, after 5 years, when they finally are winding down, that's when you can get your money back out of it. Okay. Dissociated partners are liable for any obligations or debts that were incurred while they were partners. So if there is a debt that was never paid and then they get sued, and so now this company is coming after the debt, it's a creditor from the partnership. If it was a partner in the limited liability partnership at that time, then he's personally or she's personally liable as well. Okay. However, if they're a limited partner, then they're not, because the money that they had to lose was already in it. If, however, within 2 years after they dissociate, they interact with a third party who reasonably believes that they are a general partner, they can be liable to that person. Okay? So, if you dissociate and you're no longer a member of that partnership, you're a dissociated member. But if you continue to act as a member of that partnership, a general partner, then you can be liable to that person that you were pretending to be a general partner in front of. The dissociated partner may want to file, now this is not required, but if you are deciding to leave a limited partnership and you want to dissociate, you can file something that is called a statement of dissociation. You file that with the Secretary of State, and if the limited partnership requests, or if you, the limited partner, request, then you can require the limited partnership to amend their certificate of limited partnership. Remember, when you first set up everything, you all filed a certificate of limited partnership, and your name is on there as a general partner. Now you're trying to dissociate, and so you file a statement of dissociation. I'm no longer a general partner, so I'm not going to be legally liable for anything that they do from here on out. And by the way, guys, I want you to go ahead and redo your certificate of limited partnership. I want you to file an amended certificate of limited partnership and state who are the general partners now. Okay. A dissociation, we talked about this just a minute ago, a dissociation does not entitle a dissociated partner to an immediate distribution. They get that money when and if the limited partnership decides to make a distribution in the normal course of its business, or if the limited partnership dissolves. All right, so that's how somebody becomes dissociated. They leave a partnership. What if the partnership's going along, everybody's happy, and there's a partner who wants to join? There's somebody who wants to be part of the limited partnership. How do you add a partner? Well, I'm glad you asked, because Florida statute has, in Chapter 620, there is a statute as to that, and it says that the limited partnership agreement governs. But if there isn't a limited partnership agreement on how to add a partner, if it's silent, then you must obtain written consent of all the partners. Okay, that sounds kind of like RUPA, doesn't it, when we're talking about general partnerships? Because RUPA says, hey, if you want to add a partner, everybody's got to consent. That's basically what this is. If the limited partnership agreement is silent, then Florida statutes, which has adopted RUPA says that you must obtain written consent of all partners. Okay, all all, and we know that means all general partners and all limited partners. All right. Then they are required again, after you add this partner, to file another amended certificate of limited partnership. All right, so there's a lot more forms to be signed on this limited partnership. A lot more things to file. All right, so that's how we add one. Now, dissolution, winding up, termination of a limited partnership. Dissolution occurs in the following ways. There's 3 ways, actually. There's non-judicial, there is judicial, and there is administrative. So you have non-judicial dissolution, you have judicial dissolution, and you have administrative dissolution. Well, non-judicial is per the partnership agreement. If the partnership agreement says we are going to dissolve on December 31st, 2023, when December 31st, 2023 rolls around, then that partnership it's dissolved and it begins winding up. If all the partners just get bored and they are tired of running this company and they made a lot of money at first and now it's kind of dwindling down and they just want to close up shop, if they all agree, they can. They just dissolve the partnership and it's over. If there are no remaining general partners and there are only limited partners, well, those limited partners have 90 days to find somebody or for one of them to become a general partner. But if 90 days runs and there's no general partner in the limited partnership, then they have to dissolve. Okay. If dissolving this way, the limited partnership must file a certificate of dissolution with the state. And that's to say, for any non-judicial dissolution, you have to file the statement of dissolution, or certificate of dissolution with the state. If the limited partner, if it doesn't dissolve this way, if it's not non-judicial, it's either going to be judicial dissolution or administrative dissolution. These are kind of similar, kind of not. A judicial dissolution is upon application by a partner or a court order. A court may order that the partnership dissolve. This usually means one of 2 things happens. Either the partnership was found to be defrauding its customers, and they got caught, or there is a stalemate between general partners and they can't come to an agreement, and so everything has just ceased working. The partnership's not working, nobody can get along, no decisions are being made, money is just hemorrhaging. The court will come in and dissolve that limited partnership so everybody can just wind it up, take your money and go home. Can't play nicely, then game over. All right. The final dissolution is administrative dissolution, and that is when the Department of State here in Florida will dissolve a limited partnership if the limited partnership does not pay the $411 that I told you about that they are required to pay for their annual report. They have 60 days that they can do this. They can be delinquent for 60 days after its due date. And then if they have not filed their annual report, the state of Florida will just dissolve them. So it's not dissolution like the judge has come in and said anything. It's just the state of Florida. And it's very possible that the limited partnership doesn't even know that it's been dissolved. They may get notice, or they may try to do something and they may be told, no, you can't do that because you're no longer a limited partnership. You've been dissolved. What? Yes, there was an administrative dissolution. You didn't turn in your annual report. So they might come to the office, they'll talk to the attorney, they're just verklempt and upset, and they're just, what has happened? What do I do? They dissolved us. Oh my gosh, and they'll just be up in arms. It's very, very easy. They should stay calm. It's very easy to to handle an administrative dissolution. The partnership, all they have to do, of course, there's another form for more money. The Department of Revenue gets pretty happy about this. There is a form of reinstatement. So you go down, you file the form of reinstatement for them, and then you pay up your $411 and you're back in business. All right. Winding up. Oh, and once you pay, well, I'll tell you that in a minute.